Justice Kavanaugh?
Just to pick up on Justice Gorsuch's questions, the idea of recommendations is not in the statute, and the statute does refer to organization, and the definition, as he was saying, of interactive computer service means one that filters, screens, picks, chooses, organizes content. And your position, I think, would mean that the very thing that makes the website an interactive computer service also mean that it loses the protection of 230. And just as a textual and structural matter, we don't usually read a statute to, in essence, defeat itself. So what's your response to that?
My response is that the text doesn't apply here. Let me explain why. The element in the list in F4 it refers to only one of the three kinds of interactive computer services in F2. In F2, and this is on page 267 of the petition appendix, F2 says an interactive computer service means, and it gives you three candidates. You've got to fit into one of them: an information service, a system, or an access software provider. Now, YouTube is one of the first two. It's not a software provider. The definition in F4 only delineates who is an access software provider. It doesn't apply to who's an information system or service. And that was Congress's choice. Congress didn't say you're a service, an information service or a system if you do those things. It said those things only bring you within the four walls of interactive computer service if you're a software provider. And that made sense in the context of what was happening in 1996. In 1996, if you wanted to go online, you would typically sign up with CompuServe Prodigy, and they would literally give you diskettes. They would be selling you software. And this provision in F4 is about that activity. That's not what's happening here.
Just to go back to 1996 and maybe pick up on Justice Kagan's questions earlier, it seems that you continually want to focus on the precise issue that was going on in 1996, but then Congress drafted a broad text. And that text has been unanimously read by courts of appeals over the years to provide protection in this sort of situation, and that you now want to challenge that consensus. But the amici on the other side say, well, to do that, to pull back now from the interpretation that's been in place would create a lot of economic dislocation, would really crash the digital economy with all sorts of effects on workers and consumers, retirement plans, and what have you. And those are serious concerns, and concerns that Congress, if it were to take a look at this and try to fashion something along the lines of what you're saying, could account for. We are not equipped to account for that. So are the predictions of problems overstated? If so, how? And are we really the right body to draw back from what had been the text and consistent understanding in courts of appeals?
Well, our position is that the text doesn't say this. With regard to the issue of what we've come to call recommendations, this isn't a long-standing, well-established body of precedent. It's really three decisions. The decision in this case, the Dyaroff decision, and Force. And of the 8 justices...
What about the implications then? Go to that. The implications for the economy, that you have a lot of amicus briefs that we have to take seriously that say this is going to cause a lot of economic dislocation in the country.
I'd say a couple of things in response to that. The first one is, on a close reading of the amicus briefs, it's clear that they're urging the court to hold that a wide variety of different kinds of things are protected. They're inviting the court to adopt a rule that recommendations are protected and that whatever they're doing would qualify as a recommendation.
Well, I think they're saying a recommendation is a recommendation, something express. I mean, your whole thing is the algorithms are an implied recommendation, and they're saying, well, they're not an express recommendation. So. But in any event, why don't we
Yes.
focus on the
Yes.
question? Do you challenge the basic
I
point?
think, yes,
And if so,
we do, on a couple of grounds. One of them is that I'm not sure all these briefs are distinguishing, as we have today, between liability because of the content of third-party materials and the recommendation function itself. A distinction between more and less specific suggestions.
what would the difference be in liability, in damages?
I'm sorry, between which two things?
The third-party content and the recommendation?
Well, most of the time, the recommendations
Like, how would the money at the end of the day differ if you are successful?
It might not be, but most recommendations just aren't actionable. I mean, there is no cause of action for telling someone to look at a book that has something defamatory in it. JASTA, the statute we're talking about tomorrow, is unusual in that recommendations could run you afoul of the statute, but there are very few claims that are like that. So it's a very different kind of situation. It's the implications of this are limited because the kinds of circumstances in which a recommendation would be actionable are limited.
Thank you.